Court calls the case, People versus Caleb Smith.
People.
Lawrence Margolis on behalf of Mr. Smith. Caleb, please unmute yourself. Please state your name.
Caleb Smith.
Judge, we are still waiting on discovery in this matter. It's through U of M and they are notoriously slow. The video, we got discovery from the people, but I believe we're waiting on the video download from U of M. Is that correct, Mr. Prosecutor?
So I'm not familiar with how long it's going to take for that to be downloaded and sent over to you. I do see it looks like we sent some materials last month. I can reach out to U of M to see if there's a hang up on their end. But that's the best of my knowledge as far as the download and that process.
That'd be great. That's all I could ask for. Thank you.
How much time are you going to need to?
I can reach out to them today. I'm not sure how long it's going to take them to get back.
I sent that other one for. Probable cause conference. Go to March 6, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Your Honor, if people may be heard on bond, actually.
Yes, go ahead, sir.
Your Honor, the current bond in this case, I believe, is a PR bond. I would note that people initially requested $25,000 surety. I would be renewing that request. The counts charged here, as the court can see, are carjacking, assault, intent to rob while unarmed, financial transaction device, as well as receiving and concealing. As far as the people's concern, it's public safety, and that this is a defendant who assaulted a completely unknown victim, a stranger, in a parking lot, tried to take her car, took some property from her. She suffered a broken nose, chipped tooth, numerous abrasions. I believe he was then found later with other individuals consuming marijuana despite being under 21. I think that a PR bond is not appropriate given the severity of the charges as well as the facts of this case.
Mr. Margolis.
We'd ask Your Honor to keep the bond in place. This individual was charged originally as a juvenile. He spent 4 days in custody. The case was, he was released, and at the time it was dismissed and then it was recharged. We've been working with the detective in this matter and we turned ourselves in, and then we're able to get the PR bond. Miss Burton Harris was at that hearing, or one of her people were there. I think she was at that one. I can't remember exactly that. Maybe that was Joe. He has no prior criminal history of any sort. He is an A student at Huron High School. He is on a house arrest tether. His mother is in the courtroom or in the Zoom with Mr. Smith today. He is not a threat of committing any crimes. He is not a threat of leaving the jurisdiction. We would ask Your Honor to keep the bond in place. And there's been no bond violations. I don't believe. He said something about marijuana.
Is he testing?
I can't recall, Caleb. Are you testing? I think he did test, but I don't know if he is testing presently.
Testing for what? Sorry.
Alcohol or drugs?
No, they're not testing me.
All right, young man, if I tell you to report to community corrections today to take a drug test, is it going to come back clean?
No.
What's going to show up?
Just it was from school. Just marijuana. That's it.
How old are you?
Just turned 18.
Yeah, that's a problem. Mr. Margolis, how fast can you and your client get down to the court?
Half an hour?
Pardon?
1/2 an hour?
Okay, I'll pass the matter. We'll see you then.
Thank you, Judge.
Thank you.
Yep. Okay. Go! Will you hand me my screen box? Now go. Preach.
No, not at all, Ray. In fact, I'm just going to guess. I don't know your mom, but I'm just going to guess she's probably told you not to do it.
Mm-hmm. Yeah.
So you don't listen to her, and you're not listening to me or the court. You just want to play by your own rules, don't you?
No, sir. No, I don't.
Because otherwise you wouldn't have done it last night. Man, how old are you?
18 now.
When was your birthday?
December 21st, 2006. It's my birthday.
So we turned 18 this, as I told the court, it was charged originally in a juvenile matter, and then it was dismissed and they recharged as adult.
You understand, young man, that you are facing a life offense.
Yes, sir. Yes, Your
You
Honor.
understand that?
Yes, Your Honor. It's taken a lot for me to realize what position I am in, and
I don't think you get it. You found yourself in a position where maximum penalty is life or any term of years. Have you graduated high school?
no, sir.
No, you haven't even graduated high school and you're facing a life offense. And then somebody just gives you some simple rules to follow, some simple things not to do. And you can't do that. You can't follow your mother's rules. You can't follow the court's rules. You can't follow any rules. So you tell me why, if you're just going to throw away your life, why I shouldn't just lock you up right now?
No.
You tell me why.
Been proven, sir. And
Improving how? You're smoking last night. Tell me how that's an improvement.
I do it. I'm gonna tell you why. I usually need to study or focus study, and it helps me focus while studying. I listen to music, and I honestly no harm for it. And
You will never do it.
I would never do it again. I can do it whenever I'm not addicted to it or anything. I just like it because it helped me study.
Great.
I got good. My grades are improved now. Back since I've been out, I've been having
Did you tell your mother you needed something to help you study?
I said I prefer. I actually
Did you tell your mother that?
no. No, sir.
Because you're just so grown, you took it on your own.
Sorry. I was trying to do things on my own, and clearly I messed up. And this just shows that I need my mother to supervise me and to.
You're not listening to her. I don't, and I'll be honest with you, I went through the bond form, Mr. McGoes. I don't understand how he has a PR bond. I don't.
So the family would not be able to make a high cash bond or a significant money bond. He came to the court with no prior history of any misconduct. He is high school senior, on track to graduate. I explained to the magistrate how the family has all come together to take care of this, help assist this young man through this time. He's on a tether, on house arrest. All he is able to do is go to school and church. And I believe those are the two places that he's gone to.
Yeah, those are two places that I've only been.
He is not a risk of committing any offenses. He's not a risk of
Yes, he is.
any.
Because he did it already.
It's possible, and not to excuse anything here, Judge, but it's possible that I didn't explain the conditions sufficiently to this young man.
How's that feel with your sword in your chest?
I don't think I understand the court.
I don't mind attorneys falling on the sword for their client,
Thank
but
you.
this young man is not listening. He is not. He is just going to decide to do things his way. And I think his problem is he's running to the wrong judge to try to do stuff his own way.
Understood, Judge. I would suggest that perhaps if he were to test regularly and prove to Your Honor that he does respect the court, does understand what he needs to do.
You know, Mr. McGullis, I don't mean to interrupt you.
No worries.
It's almost not so much about respecting the court, although I do require that. But you know, I'm sitting up there watching on the Zoom screen, and I see his mom just standing beside her child, And it's the fact that you don't respect her that is really irritating me. And because of that, you're not even doing the things to respect yourself. You're an 18-year-old kid up here facing life for what? And again, I don't know your mom, but you got these charges come up, you got your mom scared to death.
If Your Honor would like to speak with her, she'd be more than happy to talk to the court.
I'll tell you what, I'll hear from mom on.
Your Honor, and I probably mentioned this already, but he's in his last semester. My concern is that if he's detained for long.
Oh, I know.
Yeah, I know Your Honor knows.
I know.
I just wanted to put that out there. And
you know what? If I don't care about his education, about his life, if he doesn't care, why should I?
I think he does care. I think he's just made some mistakes. And
he's not listening.
He's never talked to you before.
Oh, I can tell.
Meaning he's listening to you, Judge.
State your name.
Nicole Barrow.
All right. What do you want?
What
do you want to tell me?
I know most moms will say that they have like a good kid and they give you this long spiel and then they do something bad and they're like, oh no, you should believe it. But when I tell you, like, I'm in shock, utter shock. He was really a good kid and still is. I did not know. I knew he had a vape, but it wasn't marijuana. And I did tell him it was bad for his lungs. Prior to that, he was my only child that I knew for sure was going somewhere. He's never smoked, never been in any trouble. Him and his brother had started a business where they were selling hoodies in school. He would even be the one, helping me around the house. He's got a brother 16 months apart from him. I moved up to Ann Arbor 8 years ago so that he could go to a baccalaureate school because my two oldest children went to Cass Tech. His older brother went to Eastern and somebody laced his weed and sent him on a trip. By the grace of God, he came back. He's got a degree now. He's going to U of M this fall for software engineering. He even got a STEM scholarship. So that was the example that I was showing my younger children. Don't smoke weed. Don't hang out with these kids. Started hanging with some new kids that were older than him in college. And then I think turning 18, he thought he could,
just thought he was
rebellious and grown.
Yeah.
And not knowing. I just ask that the court show mercy. And I know this isn't something light or to be taken lightly, the charges that he's facing. We don't consider it lightly. We come from a good background. Our family, civil rights activists. I don't know if you ever heard of Willie Barrow,
Okay.
my aunt.
Yes.
Joe Lewis, my great uncle. I'm doing well at Blue Cross. I'm making a name for myself with the CEO. I'm back in school.
Ma'am,
So he comes from a good family. I'm sorry.
I do not doubt that at all.
Yeah. So it's hard.
I do not doubt that you as a mom have tried to do everything within your power to give him the tools and everything else so he could succeed. That is not a doubt. Like I said, I don't know you, but when I saw you on the screen, it wouldn't be easy for you, but if you just walked away from your kid that might have done wrong, I don't know that anybody would blame you necessarily. You didn't do that. You were standing cheek to cheek with him.
Yeah.
So understand any decision that I make, it's no reflection on you.
Sure. I understand.
But what I also understand is I've been doing this long enough to realize if he keeps getting away with this stuff, he's either going to end up in prison or in a casket. Don't shake your head because you have no idea. You think you know too much, but I'm going to show you about what you do know. Mom, is there anything else you want to tell me?
He thought marijuana was legal and he could do that. And then they didn't tell us that the probation. I knew it's wrong, but they didn't give us restrictions or to anything to him. And I think he didn't know it because that's what he said coming in. I know it's not helpful.
I got you.
I thank you.
His bond conditions are what his bond conditions are. I understand they may not have told him, but you told him.
Yeah,
He knew.
I did. And I just asked if you do makeup on, can you make it affordable for me? It's just me. And then I've been missing work already. I've missed almost a month that they're on me. I got to go meet with my HR on Monday about my job. This is so hard. And I told him I was only messing up at work because of this. I couldn't handle it.
Okay.
I'm sorry.
No,
I'm
do
so
not
sorry.
apologize.
I'm sorry. I'm so sorry.
What time's your appointment on Monday?
In the morning when I go to work at 8 a.m. I work in Medicare Advantage. I work the Blue Cross. It'll be 2 years in May.
What time do you get out of work?
4:30. You're right.
All right. Okay. You work, how far is it from your work to here?
Oh, it takes me about 45 minutes.
To get here?
Yeah.
All right. Okay. Thank you.
Thank you.
Anything else from either side before I do what I'm going to do?
Your Honor, the people's original request was for $25,000. That was before the people were aware of the new violation with the marijuana. This time, people will be requesting refunded for the violation. I know the court indicated that I'd gone through the bond request form. I know my colleague did a fantastic job outlining all the facts. I did just want to again emphasize the severe injuries and assault that occurred on one of the victims here with the broken nose, chipped tooth. She was bitten in her hand as she was trying to fight the defendant for control of the car keys. I think remand is appropriate at this time.
Margolis.
I have nothing additional to add, Judge. This isn't the time to talk about the facts. We do have compelling defense to this case, but I'm not going to get into them now. This is a first offense, first charge of the lifetime for this young man. The family does not have money to pay a high bond. I would, if Your Honor was going to change the bond, I would suggest something in the range of 10 to 25,000, 10% if possible.
But if I make it higher than that, then family doesn't have it, and then he doesn't graduate.
Correct.
And everything's a mess.
Correct.
Hey, man, anything you want to say?
Hold on. Me. I just want to say that I do learn from my mistakes. I'm getting closer to God. I know I do look at my mistakes and I know it impacts my family and I know it impacts my mother and it really breaks my heart. I've been improving. I've been improving in school, my business. I'm helping opening up a business today actually for pregnant women for a pregnancy pillow. Like I'm trying to like do the right thing and I won't smoke again. That's no problem for me to not smoke again. I won't like. Other than that, like I've been following my probation rules. I've been texting my probation officer. I have not committed any other violations. I've been going to school on time. And I really apologize to the court. I'm sorry. I apologize to you. And that's it.
Here's something. I'm sitting there listening to your mother. And man, understand something. You will never ever possess the right to break her heart. You just don't have that right. Normally, an easy thing for me to do is to accede to the people's request. If I accede to the people's request, you're not out. You don't graduate. Everything becomes a whole mess. But it also seems that if I let you out, you can't seem to follow the rules or do anything. So what I'm going to do is I'm going to think about it. And I'm going to decide what I want to do. But you're not leaving here today, Mr. Allen. What I'm going to do is I'm going to revoke your bond. You sit there and you think about it. I'm going to set a bond hearing 4 o'clock on Monday, 4 p.m. I'm setting 4 p.m. so you can get into the building. Ma'am, you get to work. You get here. We'll be here. We'll wait for you. Okay? We'll finally have somebody that's waiting on you as opposed to you waiting on everybody else and everything falling through. But what you're going to do, young man, since you can't seem to understand what kind of life you're kind of headed to, you ever been in jail?
Yeah.
For how long?
They put me in here for 4 days.
On this
Okay.
case, Judge.
Well, you're gonna be back in. And then come Monday, you might just stay in. You have nobody to blame for this but you. So at this time, defendant is remanded. Court does call the case, People versus Jeremy Walter.
Ashalani for the people.
Torshio Feaster, Assistant Public Defender. On behalf of Jeremy Walter, to the podium, please.
Jeremy Walter.
Thank you, Judge. Thank you for giving Walter the opportunity to go to community corrections and to have his another sample given and tested. We did receive the results that sample was positive. I followed up and asked for the levels from the February 18th date to today, the 2/20 date, and those levels do appear to have gone up.
Skyrocket would probably be a word.
Well, yes, Judge, that would be accurate.
Okay.
My client, I spoke to him about the skin and asked him if there was anything he wanted to tell the court to clarify things. He's still adamant that he did not use any marijuana intentionally, and I informed him what was likely to happen, Your Honor.
May I respond?
You may.
Thank you. What's of particular concern to the people in this case is that really the 218 test, the test on Tuesday, is our first test.
Correct.
The defendant was placed on bond, I want to say the middle of January, but I'll have it pulled up here in just a moment. And at the time that he initially went on 117, he said he didn't have the money. 127 he missed, 24 he missed, 214 he refuses, 218 we finally get a test and it's positive, and today 220 the test is increasingly positive. The reason that I'm particularly concerned in this case is because there are underlying mental health issues at play. The people do believe that we're at least in part responsible for the things that led to the charges. In my professional experience, the combination of THC with mental health challenges can be really disruptive and can be difficult. I am very concerned about the defendant and his behavior while on bond. And I will leave any decision about the bond violation to the court's discretion.
Only thing I can say to his credit, Judge, that he did go test when we ordered him to. He come back. He did not flee, run. He's not sure how it's got in the system. He did have some housing insecurity. When he thought there might be some using at that location, he left that housing location to make sure he was not around any narcotics. He's not sure how this could have occurred, but he's obviously very apologetic that it's positive, and he understands the court's how the court treats these situations generally. I've made that very clear to him, but he says that he has not been using to his knowledge, Your Honor.
I'm not even sure what to say. I mean, as I'm looking at this, it's clear that first of all, we had a series where he's not testing. Then he's unable to test. Then he tests, it comes back positive. Then we're not necessarily dealing with it at that time. And then I get him here and he's got an opportunity to tell me something's going on. And he's telling me it's all he's not sure, or some mistake on his part. And then I get the levels and it's clear it's not a mistake.
Like I said, to Mr. Feaster here, that I was, because of my bond stipulations and the no contact order with my parents, which is where I was living before, I was living in a place that I realized was not safe, and I about 36 hours ago moved out of there because I realized that people were using there, and so I moved. I put everything in my car, and I moved to my to a place where I can be safe and be private and not be around people using. So I made a significant effort to remove myself from a situation that I realized was dangerous. So I am making significant efforts. It was not easy to move, to put all my belongings in my car, and to have faith that it was going to work out for me to stay in an office of the nonprofit that I volunteer at. But I made that significant change in order to remove myself from a, potentially hazardous situation. I'd just like to say that.
Only thing I'll add, Judge, is that my client was trying to retain counsel in this case. He's met with two different attorneys. I think he's planning to have one for his next court date. I'd ask the court for the soonest possible adjournment the court is able to give him, so that he can hopefully see you again and have new counsel present for that next court date.
Probable cause conference will be adjourned to February 27th. I'll set it to next week, 2025, 9 a.m., or as his invite indicates. At this time, given the positive test, I don't believe that the defendant is telling me the truth at all, that he's intentionally violating the conditions of his bond. So for those reasons, I'm going to revoke the defendant's bond. The defendant is remanded.
Thank you very much, Judge.
We are on the record in the matter of Shelley Berrien, 24102. All right, and Ms. Berrien, your name please. Shelley Berrien. All right, thank you. And so today is the date scheduled for two things, a jail review as well as a probation violation. So Ms. Berrien was sentenced to probation on May 1st, and that was on her plea to amended charges of disorderly conduct. It was under 771.1. The breaking and entering without permission and assault battery were both dismissed. There was a probation violation November 12th, whereby the client pled guilty, and as a result, there was increased testing, the chemical awareness program, and continued under advisement. The court indicated that for any further violations under advisement would be revoked. On January 13th of this year, your client pled guilty to another probation violation. The court extended probation until May 1st. The court also indicated that there would be 10 days jail and suspended it. The court also held the matter of under advisement in abeyance. Now, here we are for a third violation that's alleged, where it's alleged that your client tested positive for alcohol and marijuana on January 24th, a mere 11 days after she was last in court. So, counsel, what are we doing with the probation violation?
Well, Your Honor, I discussed this matter with the probation as well as the recommendations with Ms. Berrien. She understands she has a right to a hearing based on my discussions with her. At this time, she would plead guilty to the probation violation. However, Your Honor, there's an explanation, at least, with some. She understands the recommendation that is in the file, and I'm here to hopefully dissuade you from doing it.
Okay, ma'am, please raise your right hand. All right, and you heard the allegations, correct? Yes. And as to those allegations, how do you plead? Guilty. And you've gone over your advice with your attorney, correct? Yes. And you understand all of those rights? Yes. You understand that you do have the right to have a contested hearing in this matter. And by entering into a plea, you'll not have that contested hearing. Yes. You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency. You understand that? Yes. And you also understand that this would be technical violation number 5, and the recommendation in this matter is for probation to be revoked. Under values, it has to be revoked. $50 probation violation fee and serve 10 days jail. Okay. Knowing all of that, do you want to continue with your plea? Yes. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
And counsel, if you can please go to your client.
Thank you. Ms. Berrien, you're placed on probation to this court, is that correct?
Yes.
And the terms and conditions of that probation are that you are not to consume alcohol, regardless of the source, whether it be from beer, wine, mouthwash that has alcohol in it, any of those circumstances, as well as you are not to take any type of medication which is not prescribed. Is that correct?
Yeah.
And did you tested positive for, I'm sorry, let me rephrase that. On January 24th of 2025, you took a drug test. Is that correct?
Yeah.
And you tested positive for marijuana as well as for alcohol. Is that correct?
Yes.
And did you consume, let me put it this way, did you take any type of marijuana in any way, shape, or form?
Yes.
And was that gummies because you have a back problem or?
Yes.
Okay, and you don't have a medical marijuana card, do you?
No.
And when you were getting ready to leave, you consumed some mouthwash which may have alcohol in it. Is that correct?
Yes.
That's satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation. Indicate technical violation number 5 will enter. And, okay, let me ask this question first. So I've heard two. I heard the marijuana and the alcohol. And so the marijuana, you don't have a valid prescription from a doctor, is that correct?
No.
Okay, I guess that's a double question. Do you have a prescription from a doctor for marijuana?
No, I don't have a prescription.
And it was indicated during the voir dire that you used the gummies because of a back issue.
Yes.
Okay, so have you had communication with your doctor regarding a prescription for marijuana?
Do I have a medical marijuana card?
No, ma'am. Have you had a conversation with your treating physician regarding the back pain and whether or not they would recommend a prescription for marijuana?
I've had a conversation about it, but not about the marijuana, no.
Okay. And you're aware that you can't use marijuana without a valid prescription, correct?
Yes.
Okay. And you're also aware that this court indicated any further violations and the court would revoke your under advisement status. And then you also have the 10 days jail suspended that's pending. You understand that? And despite that, you still chose to use marijuana, right?
Yes.
Okay. And then, ma'am, you've been testing now for, what's it been, 9 months?
I believe so, Your Honor.
Yes.
Okay. And so you're aware that you have to pay attention to the ingredients in the products that you consume, correct?
Yes.
And so you want this court to believe that you use mouthwash and that's why you tested positive for alcohol. Right? That's what you want this court to believe.
Your Honor, I discussed that portion of it with it.
Hold on, excuse me, just a moment, counsel. Ma'am, what time of day did you test on January 24th?
I can't recall if so. I believe in the morning after I took my daughter to school.
Okay. So when would you have used the mouthwash that you're saying that you used?
In the morning, I'm fresh.
Okay. And do you swallow the mouthwash?
No.
So interesting how that would then be detected in your urine. Is that how you submit a sample, is through your urine?
Yes, ma'am.
Okay.
Can I,
Go ahead.
can I say something?
Okay.
Because I also, like, I use alcohol for everything though, like I cleanse my face, maybe the sprays or the perfumes
And yet
or
it
something.
doesn't, and yet it doesn't test positive. But this time it tested positive. So if you routinely use alcohol sprays, or you know, have, if it's an ingredient in your skincare product or something of that nature, and you've been using it the duration of probation, and you haven't tested positive, that's because it's such a minuscule amount, and it's only on the surface, and it's not absorbing your skin for you to test positive with a urine sample. That's why I don't believe that it was mouthwash, and that there was consumption of an alcoholic beverage or two. Yes, Council.
I've discussed this with her, and she's indicated to me that she can only think the only time and the only reason that it's in her system, the alcohol. There is a violation with respect to the marijuana, that this is how it occurred. She's insisted to me that she did not go out to the bar, for example, have a couple beers and then test. And indicated that's the only reason she feels that this has tested positive now.
Okay, well, in my experience, and in all the testimony that I've heard regarding consumption of alcohol and positive tests and things of that nature, with Ms. Burian not, you know, with her spitting out the mouthwash, that it wouldn't have been absorbed into her system to test positive in a urine sample.
I understand, Your Honor.
But in any event, you should be using non-alcoholic mouthwash. And if you've been using the same mouthwash through the duration of your probation, right?
No, I switch it.
Okay.
This is a new bottle I got.
Okay.
Or, yeah.
All right. So, but you've still been using this mouthwash. You haven't tested positive for alcohol prior, and you've been using alcohol-based skincare products, and you haven't tested positive for alcohol. That tells me that there is alcohol consumption. But even if you didn't consume the alcohol, ma'am, you are very much given the information as to what products are products that you should stay away from, and that you have to, it's your responsibility to review the ingredients before you consume anything.
She understands that, Your Honor. That's what we discussed.
Okay. And so, Counsel, why should I not adopt the recommendation?
Your Honor, I think, and the court is true, it's right. This is her first violation, from what I understand, regarding the alcohol. It's interesting to note that both this and the marijuana, the gummies, was all on the same day, it wasn't two separate instances. And, Your Honor, I know that the court has given her the opportunity to check with her treating physician, and if that is the appropriate remedy for back pain, under her circumstances, then this is what she should be doing. I'm only asking that it appears that the rest of her probation she's done classes, done other portions of it. And I would hope, most importantly, would hope that the court would give her a final chance to preserve or make sure that she can keep that 771 status. I think that's one of the important things. The other important thing is to show to this court that she can follow directions, read the directions on a bottle of mouthwash, make sure she doesn't swallow it, and make sure she doesn't use mouthwash which contains anything I know there's money due and owing, and probation has been extended, I believe you indicated, to May 1st, that had she been successfully completing it, she should have been on probation. I guess it's for
Right,
all,
but she didn't, she had violations.
I know, that's what I'm saying. That's what I'm saying. Had she not violated, then she would have been off by now. I guess that's the reason why I'm asking that she be given one more opportunity.
Okay, council, kind of out of opportunities.
Pardon?
Out of opportunities.
Oh, I see that.
Because this is the 5th technical violation. When your client was here for the November 12th violation, I, at that point, continued the under advisement. And I indicated if there are any further violations, it would be revoked. There was a further violation. And that's when she tested positive for marijuana December 19th. And the court extended her probation, held the under advisement in abeyance. I didn't revoke it at that point. I still gave her another opportunity. And I also ordered 10 days jail. I suspended that, which was another opportunity. 11 days. 11 days, and there was already another violation.
Well, I understand, John.
And while one of the violations, I think that was the November one, indicated there are no payments, have you made any payments, ma'am?
Yes, I made payments. I remember. I was making payments.
Okay, I was just asking, that wasn't a violation, I was just asking if you've been making payments.
Yeah.
Are you working, ma'am?
Yes.
Where are you working?
I do,
For yourself, sorry.
no, yes, I do care, and then I manage at the mall retail store,
What store do you manage?
VIP work.
And what is your typical schedule?
Weekly it changes depending on my kids. So maybe sometimes 5, 4 days.
And how old are your kids?
14 and 8.
And where are they right now?
One is in the courtroom, and the other one's at home with grandma after school.
Okay, so grandma can take care of the kids? Because you're serving your time in jail, ma'am. I'm not adding additional time for this violation. I'm keeping it at the 10 days. I'm not adding additional time, but you're serving your 10 days. So grandma can take care of the 2 kids?
No. Can I just say something?
Sure.
Am I allowed to say something?
Sure.
Can I just ask that you just grant me mercy and grace? This time I can take substance abuse classes outpatient. I have someone here actually from the program. If there's just any way so I can, for my responsibilities for my kids.
This court has given you mercy and grace multiple times. This is the 5th violation. The 5th violation. The last time in January, I said I would hold the under advisement revocation in abeyance. And that was after I had previously stated your under advisement was going to be revoked for any further violations. And you had another violation. And I still gave you the grace to continue on your under advisement status. 11 days later, there's another violation. So, ma'am, you're serving your 10 days. The court's revoking your under advisement status, the court's revoking your probation, you're going to serve your 10 days. And again, I didn't add any additional days for this violation. This is the 10 days from your violation from November that the court, from January 13th that the court suspended. Because again, I gave you an opportunity and grace to get it together. And then you went ahead and you violated again, 11 days later. The one thing I will give you an opportunity on, ma'am, is I will give you the opportunity to make arrangements for your children. And then you can report tomorrow night. Is that sufficient time to make those arrangements? That's what I will do. Yeah, so you're gonna stop over probation, you're going to see Ms. Shaw. She's going to give you the information regarding reporting and where you have to report for jail. It won't be here, it will be at the Wayne County Jail, which I think is now known as the Criminal Justice Center.
Criminal justice.
Okay?
Thank you, Ron.
All right, thank you. Good luck to you.
Thank you.
We're on the record in the matter of Amy Hammett, 24346A.
Good afternoon, Your Honor. Your Honor, John Goldclaw, P. 30758, on behalf of Ms. Hammett. Ms. Hammett, would you please put your name on the record?
Amy Hammett. All right, today's the date scheduled for probation violation. So being technical violations 3 and 4, it's allowed you to test positive for cocaine and alcohol on January 24th, and then you failed to appear for a drug test on February 13th. Counsel, what's happening today?
Your Honor, I've had an opportunity to discuss this with Ms. Hammett. We've also reviewed the recommendation. I've explained to her right to a hearing in this particular matter, and at this point in time, she would plead guilty to the violations.
I'm sorry, she's pleading guilty, you said?
Yes.
Yes, okay. Please raise your right hand. You solemnly swear from the testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth? Yes. All right. And so, ma'am, you heard the allegations, correct? Yes. And this is, let me just clarify, this is for probation. Your client's currently on probation for possession of drug paraphernalia. The possession of controlled substance have been dismissed. And ma'am, as those allegations, how do you plead? You've gone over your advice of rights for probation violation purposes, correct? Yes. And you understand all of those rights? Yes. You also understand by entering into a plea that you'll be waiving some of those rights, specifically your right to a contested hearing? Yes. You also understand the possible penalty as a result of your plea? Yes. And in fact, you've had, the recommendation in this matter is for probation to be revoked, case closed without improvement, $50 probation violation fee, 15 days jail. Correct? Yes. And knowing all of that, do you want to continue with your plea? Yes, Your Honor. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? No. And counsel, if you can please go to your client.
Thank you. Ms. Hammett, you've been placed on probation to this court. Is that correct?
Yes.
And as part of those terms and conditions of probation, you were required to abstain from any all non-prescription drugs, and also to abstain from alcohol. Is that correct? You're also ordered to attend drug testing when your number came up. Yes. Yes. Did you test positive for alcohol and cocaine on 1/24/25? Yes. And did you consume cocaine and alcohol on days prior to that? Yes. Okay. And did you fail to appear for the drug test on the 13th of February? Yes. Thanks, satisfied, Joe. The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your probation. Your plea, your probation violation, indicate technical violations 3 and 4 will enter. And counsel? Ms. Hammett, why did you fail to appear for the drug test?
I didn't know. I check it all the time. I didn't realize I was.
Your number came up?
Yeah,
Okay.
I just missed it.
And you've seen the recommendation.
Yes.
And that's to revoke probation and close without improvement. Is that right? Yes. And also to serve 15 days in jail.
Yes.
My understanding is that you've attempted to get into certain drug programs.
Yes.
You've lost your
Health insurance.
And that you've had contact with Marcy regarding how to resolve this incident. Is that correct?
Yes.
And she's put you on with Dream?
She gave me you want me to explain that?
Yes, please.
Okay. I was seeing through teen wellness, I think, for mental health and everything. But I lost my health insurance. So Marcy gave me a printout of different places, and she recommended the Dream Center of Wyandotte. I was able to get a hold of them to get substance abuse counseling, which I have an appointment on the 26th. And they also gave me information on how to apply for a grant to get help covering it, because now that I don't have my insurance, I can't do any of my mental health therapy or get my medication or anything either. So they said, and then that will also help like fast track me getting like help through the state with health insurance.
Okay. I believe the last time it's obvious that she needs continued assistance. I believe, Your Honor, that at this point in time, revoking probation and just saying, okay, pay the rest of what you owe, and I don't say that flippantly, is the way to go. I'm asking this court's leniency at this point in time to allow her to continue on probation, take these steps that are necessary to get her into some sort of additional drug abuse, mental health, as well as, drug abuse or substance education, and continue her on probation. If the court wishes to hold 15 days, which is, I guess, you don't really want to, is to hold this in abeyance and for a period of time, and have a review as opposed to a violation of probation. Of course, if she were to violate probation again, then that's all bets are off.
Just a moment, counsel. Ma'am, yes, if I test you right now, what's in your system? No. Nothing at all? Nothing.
Can I say, when I tested, I'm sorry, it was 3 days after court. I hadn't done anything. It was just still left over in my system. And I mean, I know, I understand that's, I can prove that.
Hold on, ma'am. Hold on.
She was in court, Your Honor.
You were in court January 21st.
Yes.
Right.
So are you telling me that you had consumed alcohol and cocaine that morning? That day before court?
No.
The day before?
Your Honor, I believe she did tell you that. I wasn't here.
No, I had just said that I was struggling. I wasn't, I hadn't just done it that day.
Okay, so then it wouldn't still be in your system on the 24th.
I had not done cocaine for days before court. I don't know, I'm telling you the honest to God truth, I had it. I was blindsided when I had this positive. I just found out last night. I had no idea because I had not done nothing. I did have drink, I'm not gonna lie about that, but the cocaine, I had not done any cocaine in at least 4 or 5 days before court. So I don't know why it would still be in my
It's still
system.
pretty high. It's still, when I say it's a pretty high level, because it's a pretty high level for 3 days later or 8 days later, right? Because it typically doesn't show up that much longer.
Right.
That's why.
I
And I
understand.
believe, Your Honor, and again, she and
Yeah, that's my husband.
her husband, we were talking back there, and he was there last time. When you asked her that same question, she said yes. She had used a couple of days before, as well as the alcohol, but I wasn't here, so definitely the cocaine.
When did you consume the alcohol?
Maybe the day before court. I had just found out about court the night before as well. So maybe 2 days, the day before. But the cocaine I had not.
So what I'm inclined to do, well, let me ask you this question. Are you interested in the mental health treatment courts that we have here?
Yeah, I don't know what that entails, but I mean, I'm trying to get help for everything.
Okay. I'm not sure if Courtney's still here, but let's do this. Let's adjourn this until Monday.
Okay.
If you test right now, what is in your system?
I don't think anything, I swear. I messed up about a week ago, but if there's something, like if it takes that long in my system, I don't know.
Okay, so what would it be?
Alcohol?
So you're asking for this court to give you some leniency. Please keep your hands out of your pockets.
I'm so sorry.
But ma'am, you're continuing to violate probation.
I know, I understand. I'm really just, it's not an excuse, but just struggling, and I'm trying to get right back on the right track. I was finally on my medication. I was seeing a therapist, I was seeing a psychologist, and then I lost all my insurance, and I just hadn't been dealing with it very well.
So here's what I'm going to do. We're going to adjourn this to We're going to adjourn this to, please keep your hands out of your pockets.
I'm so sorry.
So we're going to we're going to set the sentencing for
Sentencing, you mean?
this, well, I'm going to adjourn the sentencing portion of the probation violation for February 24th at 11:15 a.m. You were to have an alcohol tether on today. You were to test today. Ma'am, all this is still on the table.
Okay.
And I'm going to ask you this right now. Is there anything else that will be showing up in the test today?
It should not. I did mess up like 7-8 days ago. But
Okay,
nothing should be in my system.
So what else did you mess up with?
Cocaine.
Okay.
I did both.
So you're wanting me to give you the benefit of the doubt, and you're not being 100% honest with me. Because as I'm asking you questions, your answers are changing.
Well, no,
while I appreciate your honesty, it's kind of coming a bit late.
I understand. I'm sorry. I'm just very.
When I asked you the question the first time, I expect honesty.
Okay.
You want help. You can't get the help that you need if you're not being honest about what you need help with.
Yes. I understand.
Stop work for probation. Somebody's going to give you the information regarding testing today and the EMS tether.
Thank you, Art.
Now see you Monday at 11. Well, you'll be here at 8:45 to meet with Courtney.
Thank you, Art.
Off the record.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an absolute. You need an interpreter.
I need an interpreter when I cannot express myself something.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in first. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go so fast. Trust me, after today, I'm sitting up here, I'm the one that needs a drink.